Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Fitchburg, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court sitting at Fitchburg State University. I want to express, on behalf of the entire Appeals Court, our appreciation and gratitude for having us here today. This is the first time we've come to Fitchburg, and we hope that it will not be the last. My name is Mary Sullivan, and your panel today will consist of me. To my right is Judge Lemire. To my left is Judge Dickoff, and we will be hearing 6 cases today. But before we proceed to the cases, I would also like to thank those who made it possible for us to be here today, including University President Richard Lapidus, Chief Michael Cloutier of the University Police, Jessica Nugent, the Director of Special Projects, Zach Hillman from our own court system, who helped to make this possible, Lieutenant Fisher, and his whole crew, who has arranged everything here for us today, and all the people who often go unnamed who make these things possible, such as the Fitchburg Historical Society, which has that wonderful exhibit out in the hallway. I will say that I spent many years as a lawyer at tables like that. We have a proud architectural history in our court, which is also displayed in that, as well as all the people who will prepare our lunch today, who have set up these seats, all the things that happen behind the scenes, which when done so well and so professionally, make it all look simple. So with that, I would also like to give a little explanation for those of you who may not have seen an appellate court except on television about what we will be doing today. We're going to hear 6 cases. Each side gets 15 minutes. There is no rebuttal. We will take a break after the 3rd case. You can be assured that the judges have read the record carefully. We are familiar with the facts and your legal arguments, and lawyers, you can proceed straight to the heart of your argument. And with that, and without further ado, we'll begin. The first case is Commonwealth versus Pitman.
Good morning. Francis Doran for Mr. Pitman. Mr. Pitman's probation hearing was conducted at the Concord District Court. Into evidence was admitted a previous transcript of a restraining order hearing conducted by the same justice who conducted the probation hearing.
Let me stop you for a minute. Can people at the back of the room hear?
Oh.
No. If you could lift the mic
sorry.
a little bit.
I'm sorry.
And, well, I don't know that you're going to be able to cure it, but I just thought I'd give it a try.
The introduction of the previous hearing, which was conducted in the Concord District Court, was allowed into evidence in place. It was the contention of the defendant of the complaining witness's testimony. And she was in the courthouse at the time of the hearing.
Well, counsel, there's a long line of cases that says hearsay is admissible in a probation violation hearing, correct?
Absolutely.
And your position is that the judge should have found good cause why hearsay was needed here.
Well, I believe that the jurisprudence has evolved to the point where they're saying reliable hearsay in some way will account for the unavailability of a witness. And I believe that's how it has resulted. The problem is that by introducing the testimony, it puts the Commonwealth in a position to allow it to conduct a tactical choice, which is the admission of the transcript will absolve the complaining witness here, in the underlying case, which was dismissed on that day. It will allow her testimony to go in as previously recorded in place of her live testimony.
But she was unavailable.
She was there.
She refused to testify in the underlying case. That makes her unavailable.
The judge made a finding on that day that she was available. The Commonwealth decided to dismiss that case, notwithstanding her recalcitrance to testify. So she was deemed an available witness. There was no privilege that she could have asserted to escape her obligation to testify. The Commonwealth made a decision on the underlying case, the criminal case, which was conducted just prior to the restraining order. The judge made a finding of her availability. So she was there in the courthouse. She's available to testify in the criminal case. I don't see how she can't be deemed available to testify in the probation case. If there are going to be any rights of confrontation, and the federal courts and the Massachusetts jurisprudence does recognize that there is a limited right of confrontation in these type of proceedings. If there's going to be any right of confrontation, this type of scenario cannot be countenanced, in the sense that if the Commonwealth is allowed to pick and choose as to whether we're going to expose her to cross-examination, this is an instance in which that operates as a complete discharge of whatever rights of confrontation that my client would have had.
So why not you call the
Well,
victim and you could get your cross-examined that way?
That's true, but the question then becomes, can the Commonwealth satisfy its burden of production by introducing the evidence as I've mentioned? In other words, can the Commonwealth's got to go forward with whatever evidence it's got. The question is can the Commonwealth use this type of evidence to discharge its right of production, or its burden of production? So it is absolutely true that I could have called her as a witness, but the question then becomes, could the Commonwealth satisfy its burden of proof by doing this?
But is it your position that her availability alone is all that has to be shown, or there has to be good cause why hearsay is allowed?
Well, I think the good cause prong of Durling, as you go back, has been somewhat accounted for with the idea of reliable hearsay. And I do not want to rest the defendant's argument in this case based upon the failure of the Commonwealth to show good cause. I'd frame it more in terms of an overarching concept of due process, that there has to be an accounting for some right of confrontation in this type of proceeding.
Probation violation hearings have traditionally been allowed certain due process, but not the full penumbra of due process rights that are attributed to any criminal defendant.
Absolutely. That's the law. And there's nothing really I'm going to say that would disagree with that.
Is it your suggestion this is a case of first impression?
I have not read any cases where in which the testimonial evidence has an available witness in the courthouse. It's always the police officer who may or may not be able to make it. Perhaps an individual will assert his or her Fifth Amendment rights. There are all kinds of cases which create an unavailable witness. In a sense, one being, I think, more technically unavailable, say the police officer who's in another jurisdiction or something such as that. But I have not read of any instance in which there's an available witness in the courthouse and supplanting his or her testimony by a prior transcript to discharge the Commonwealth's burden of production.
Thank you.
Thank you.
May it please the court, my name is Ashlee Mastrangelo, Assistant District Attorney for Middlesex on behalf of the Commonwealth. Your Honors, this case is being appealed from a violation of probation hearing out of the Concord District Court, where Judge Singh took a transcript of prior sworn testimony of the named victim from an extension of a 209A order hearing in which she also presided over that hearing. At the hearing, the named victim, both in the underlying criminal case and seeking the restraining order, testified in detail about her personal knowledge of the acts which the defendant was alleged to have committed. She was subject to cross-examination by his defense attorney at that time, and the defendant was present. That transcript was provided in discovery to the Commonwealth for the criminal trial. The morning of trial, the named victim expressed an unwillingness to testify, and a voir dire was done before Judge Singh for a forfeiture by wrongdoing. The burden was not met for forfeiture by wrongdoing, and if you'll note in my brief on page 6 and 7, footnote 2, the Commonwealth disputes the fact that the defendant rests on in his brief that the named victim was in the courtroom. In fact, one of the factors that went into the Commonwealth not answering ready for trial was that after testifying in the voir dire, the victim had a panic attack. She began suffering panic symptoms, felt as though she was going to pass out, and was taken to the hospital by a friend.
That's not on the record, though, anywhere, is it?
Your Honor, in the transcript, there is a sidebar with Judge Singh where I placed on the record that the named victim was having a medical emergency, and we were concerned whether or not we needed to call an ambulance. Her friend ultimately ended up driving her to the hospital, to our knowledge.
All right, but it's not clear on the record she's not there.
There was no specific finding by Judge Singh that she was not present in the courtroom. However, also in turning to my brief, and the case law well settles this as well, that unavailability need not be found in order for the court to proceed on hearsay, so long as the court, and in this case Judge Singh, finds that hearsay to be substantially reliable, which the court did. And she did issue a written decision where she noted in her decision, and just a few points from that the defendant was present for the underlying hearing where the transcript was created, that his attorney cross-examined the alleged victim, that the court made a finding, and I would note footnote 3 of her decision, other exhibits were also received into evidence and considered to the extent that they provided context or had bearing on the credibility of witnesses. However, the court relied on the December 1st, 2016 transcript for the substance of that violation. So by Judge Singh finding that the hearsay was substantially reliable, she is permitted and properly admitted into evidence that transcript and relied upon it in the violation.
Counselor, which police report is the police report that was admitted at the violation hearing? There's 2 attached to your stay opposition. It wasn't clear to me which one was the one that was Exhibit 1.
Your Honor, I believe, if my memory serves me correct, that it was the Maynard police report for the underlying offense. I believe it was.
There was an Officer Hool and a Detective Sweeney report.
Correct. I believe it was Detective Sweeney who also testified at the hearing as a witness for the defense.
You can keep going.
Thank you.
Since you mentioned exhibits, I wanted to nail that down.
Yes, and so, Your Honor, the defendant in this case rests his brief on improperly on the fact that the court should have found that the victim was unavailable. And again, I would point to both Commonwealth versus Durling as well as Commonwealth versus Calvo that, and in looking at Commonwealth versus Calvo, at a probation revocation proceeding, the opportunity for confrontation may be denied for good cause. However, when the hearsay evidence has substantial indicia of reliability, and it bears that indicia of reliability and is trustworthy, a showing of good causes obviates the need for that confrontation. And so, Your Honor, that is what occurred in this case. Judge Singh made a written decision. She found that hearsay to be substantially reliable and properly admitted it into evidence.
What do you say to defense counsel's argument that the issue is not good cause, but the issue is the right to confrontation, and that there is a due process issue lurking where the witness was at least at some point present in the courthouse?
2 points to that, Your Honor. First, in looking at Durling, which the defendant relies upon heavily in his brief, Durling states pretty plainly that a probationer need not receive the full panoply of constitutional protections. And in fact, another case law that due process at the probation revocation hearing is flexible process. So a probationer is not afforded the same rights as a pretrial defendant.
Do you think in that context it matters that the judge had actually personally heard the testimony?
I think it's akin to a motion judge hearing a trial. I think it would be akin to that. And further, I think that though it is flexible due process, what is unique about this case is the transcript, the hearsay that is actually the substance of this was a transcript where she was cross-examined by defense counsel. So there was process in that sense in this case as well.
Do you think it'd be different if there had been a hearing that Judge Singh had seen but that had not had the defense lawyer a part of, the defendant's lawyer?
I do not, because, again, I think the judge need only find that the hearsay is substantially reliable and make that determination. Certainly a transcript where someone is sworn under oath does bear some indicia of credibility, and the judge, in their discretion, if they make that decision, certainly it would be enough, although I do think it's one additional unique factor in this case.
All right, you all set? All set?
Thank you, Your Honor.
Thank you.
Okay, the next case is 17P0991, Commonwealth versus Wood.
Good morning. May it please the court, my name is Eric Rubin. I represent the defendant, Alan Wood, in this appeal from his convictions in the District Court of Framingham involving possession and conspiracy involving controlled substances. Your court's familiar with the facts here. Mr. Wood lived in or shared an apartment with Mr. Brown, and here we have the only evidence of anything involving Mr. Wood living there is his documentation, which was found in his bedroom. All of the drug paraphernalia that was found was in the common area, and there were no drugs. No drugs at all until Mr. Brown showed up, and he happened to have them in his socks. His timing was certainly bad for my client. That he appeared shortly after the police executed their warrant. Had he not arrived at all, there really wouldn't be a case.
Well, the document found in his bedroom was a bill, correct?
That's
Or
correct.
More than one bill with his name on it and the address of the apartment.
There's no question he lives there.
And then there was what the police expert described, and I'm sure you'll want to address it, as a drug ledger, including something referring to Al's contact list.
Yes.
I'm putting it out there because I know I have the microphone, and this way the people
Oh,
in the
yeah,
back
sorry.
can understand the facts.
Thank you, Your Honor. I'm usually too loud, so I will do my best to modulate. Yes, there was a ledger which the police expert and the only witness in the entire case opined was pure proof that my client was involved, because at the top of that ledger was the phrase Al's contact list. Not Mr. Wood's, not Alan's, just Al, which frankly, I would argue does not raise itself to the level that a motion for a directed verdict, it would not have carried the day on that motion, which is why it was ineffective assistance for the attorney not to make that motion. Now I understand. I'm sorry, Your Honor.
I'm at a loss. What did the lawyer do at the end of the Commonwealth's case?
Well, he rested.
Well, he
And then
argued that there was insufficient evidence. Now, I think I don't recall in the record that he said, "I rest." He just started arguing as I read the record.
That's
so,
correct.
if the judge said that's denied, he had the option of presenting evidence or not, but he argued a required finding standard at the end of the Commonwealth's case. So how is that ineffective?
But it wasn't a motion, Your Honor. Now
Not a
we're in
written
position-
motion.
I'm sorry?
Not a written motion.
Well, and in fact, it really wasn't a motion, Your Honor. He went right to his summation. if
How
you
is
will,
it
for
any
his bench
different?
trial. Well, the standard here is if he is, I can bring to the court the argument of ineffective assistance of counsel and that this should have been a motion. My client is put in a very strange position of me having to argue the judge got it wrong, which never carries the day in the appeals court.
Aren't you simply arguing there was insufficient evidence to substantiate the conviction?
Yes, that's accurate too. But
And can't you argue that whether or not you think counsel was effective or ineffective?
well, I will happily argue it. Either way.
I don't know if we're going to let you bring in a new argument of substance, but you argued it indirectly through ineffective assistance. Is that what you're saying?
That's what I'm saying, Your Honor. I'm not catching the Commonwealth by surprise if I said there was not enough evidence. It's within my entire brief that there wasn't enough evidence. And I don't mean to argue.
It just threw me off, the ineffective for not raising required findings when it appears as though that's exactly what they did,
Well-
but not by a formal motion.
Potato,
Okay.
if I may. But what we do have is we have all kinds of materials that could be, well, I feel like you know the facts in this situation. The real issue here is that's all that ties my client. My client's in the house, in this one-bedroom apartment, with diaper bags, and in walks in a drug dealer with drugs on him, and suddenly my client is in a conspiracy.
Well, there's diaper bags, which is a term used in drug dealing. There is packaging, there is ledgers, there is obvious association between the two individuals that were in the house. And so the issue is whether the jury could find, based on those facts, constructive possession on the part of your client.
Thank you, Your Honor. And yes, there has to be more than just presence to prove constructive
Well, that's
possession.
why I said the other items, packaging materials, drug ledgers that have been, I mean, that's a question of weight for the jury to determine if those are in fact what they purport to be.
Right, and obviously this was a non-jury case, so it was up to the judge to make that determination. But he has to find intent, and we don't believe that intent for either the possession or the conspiracy was available through this one witness's testimony.
What about the fact that the defendant doesn't open the door when the police come and knock, even though it's a very small apartment? How do you explain that? It seems like it might be conscious of guilt.
I don't have an explanation except that it's quite possible he didn't hear it. My client is of advanced age. Another fact that could argue toward him not being in a drug dealing conspiracy.
How old was he at the time?
Be careful.
Well, he certainly could have sat on the court. He just couldn't. It's a little late for him to be drug dealing.
How old was he?
I don't. 72. I will take the Commonwealth's word for
You're
it.
safe.
That's a pretty good answer.
It works for me, so that's why I'm taking it. Thank you. Intent has to be shown for conspiracy just as it had to have been for the constructive possession. And the fact that my client is merely sitting there and has bills and lives there is not enough. They didn't show, yes, the word Al's contact list, or the words I should say, were at the top of a ledger. And then
Containing the names of known drug dealers, and he also had the identification, was holding the identifications of other people who the police witness testified were known drug dealers, and he further testified that that's a common practice to make sure that you get paid.
But, Your Honor, when you say he was holding, he wasn't literally, he didn't have them in his hand.
Correct. No, I mean, generally,
They
yes.
were in the common area.
They were in the common area.
Right, and that again goes to, Mr. Brown is the man who walks in, Johnny on the spot, after the warrant is executed, with his 11 or so bags of crack in his pockets, or excuse me, his socks.
His sock.
So this is really about whether the fact that there's material and there's my client near the material, is that enough? And I would argue it is not.
Do you
Thank
know how we wound up getting a trial with both possession with intent to distribute and conspiracy at the same time?
I do not know that, Your Honor, I'm sorry.
Right.
Okay. And what do you think your best case is for the notion that there's not enough?
You mean,
The best legal case, precedent?
well, I do like the case of Mankini, which I've cited in my brief, which is a federal case, where a woman rented on the grounds where this bar full of steel cylinders full of marijuana, and the smell of marijuana was pervasive across the property, and she was there. She had nothing else to do with it.
Okay.
Attorney for Middlesex on behalf of the Commonwealth. I also don't know how it came to pass that the possession and the conspiracy were tried together. I will only say there were numerous court dates that before the actual trial, and it may be that at one of those not transcribed and not appearing in the docket, the defendant requested that they be tried together. He certainly raised no objection to their being tried together. It's not been raised on appeal, it's not been briefed, and so I submit it's not before the court.
And it was jury waived.
It was jury waived.
Yeah, plainly the 9E problem isn't such a problem when you have a bench trial. But
Right.
It was a curious
Right.
fact.
Yeah, it was to me too, and I don't know the answer. The evidence here, and the Commonwealth understands this is an argument about sufficiency of the evidence. Even if defense counsel had sat absolutely silent after the Commonwealth rested, this court would still review for sufficiency of the evidence under the same Latimer standard, because a conviction on insufficient evidence is a substantial risk of miscarriage of justice. It's actually, I think it's an actual miscarriage of justice. It's not even a risk. So it doesn't affect the standard. It doesn't matter. You can package it as ineffective assistance. You can package it as simple insufficiency. The evidence was not insufficient just because the drugs or packaging materials were not found in some private place that only the defendant had access to. If you look at the totality of the evidence, you have clearly the defendant lives in the apartment. It's a very small apartment. There is clear indication in the form of these already cut plastic bags, the corners cut off to hold drugs, in the trash can, that this apartment is the base for a distribution operation. You have a drug ledger, what is clearly a drug ledger. It has weights and prices. It has the names of known drug users and drug dealers, and it has a heading that says Al's contacts. There is only one person in that apartment, living in that apartment, who would be likely to be called Al. In the light most favorable to the Commonwealth, this is sufficient to establish that the defendant is at the very least an equal partner in this distribution operation, if not the person directing it, and that's the case even if he never physically touches the drugs.
What's your best case for that?
I think our best case actually is, perversely, our best case is Boria. Because Boria is the case where the defendant is in the apartment, that there is a distribution operation happening is clear, and I think the court in Boria says if she had eyes, she knew what was going on, but there was nothing to tie her to anything except the apartment itself. And here you have the defendant's, in the light most favorable to the Commonwealth. No, it's not impossible that Al could be someone other than the defendant. Maybe Brown's nickname is Al. Although Ed's name does appear in the Al's contact list. In the light most favorable to the Commonwealth, it's sufficient to establish that the defendant actually had a directing role in this operation, that he was the one who maintained the contact list. The Riz, who is Robert Hairston, and this is actually in the trial record here, was a major player in a multi-county drug conspiracy.
But what about conspiracy?
And is probably the supplier.
What about conspiracy? I mean, the person with the drugs, who I assume is the conspirator, is also on the contact list, suggesting maybe he's just a customer. How do you get to conspiracy?
There's an agreement with the co-conspirator to violate the drug laws, and if you had only the list, then you might have that question of, can there be a conspiracy to distribute drugs when the co-conspirator is the buyer? And I think Commonwealth v. Contras makes clear, again, this is not raised, it's not argued, it's not briefed, but it's possible to have a conspiracy where the co-conspirator is the buyer. But when Ed Brown walks into the apartment with 16 bags of crack tied up in the corners of plastic bags like the ones that we saw the corners cut off of in his socks, again, in the light most favorable to the Commonwealth, that's sufficient to establish that Ed Brown is not just a buyer of drugs.
I was going to say, don't you have to have some evidence that Ed Brown is selling those drugs to a third party in order to prove conspiracy under some of our recent case law in the appeals court?
I don't think so, but again, that question, I haven't dived deep into that because it's not argued here. But I don't believe that's absolutely necessary. And in any case, the fact that he's got what appears to be inventory in his socks. You had 20 cut-off corners, and he's got 16 bags in his socks.
Okay, so you're saying from the 16 bags in the socks, one can infer that he's selling?
I think
Is there
so.
any other evidence in the record from which one can infer that Brown was selling? Is his place on the contact list or his girlfriend's names and numbers, does that add anything, or is it simply?
I'm not sure it adds anything. The witness testified that 16 bags of crack in your socks, individually packaged, is not consistent with personal use.
Brown lived there too, didn't he?
It
Or there was some
appears-
evidence that he
He
was
seems to have paid
sta-
the cable bill, which came addressed to him at that address. There was someone sleeping on the couch who we assume was Brown, and not the defendant, who was 72 years old. We assume he got the bedroom. If there are no further questions.
Yeah, just for the benefit of the students, this 72-year-old man got time served.
30 days, time served.
30 days
yes,
time served,
deemed served.
just-
His advanced age was a strong factor in that resolution, I believe.
Yeah, I don't remember the Commonwealth being particularly objecting to that
No.
disposition.
No, we did not. I will ask this court to affirm the judgments.
Okay.
Thank you.
Thank you very much. The next case is 16P 1226 Commonwealth versus Lawrence J. Bradley.
Good morning, Your Honors.
Good morning, Mr. Simmons.
Joseph Simons for Lawrence Bradley. Your Honors, Mr. Bradley is arguing that this court should vacate his conviction for a second offense, OUI, in the Lowell District Court. The main contention that Mr. Bradley has is that his trial attorney asked the court to give a Downs instruction, which would inform the jury that they shouldn't consider whether or not that the fact that there was no evidence of a breath test, and the court denied that instruction.
Just before you go too far, on the standard of review, you're suggesting this is a preserved error.
I am, and
And is it because he requested the charge? He didn't disagree with the judge's position that she would only give it if the jury raised that issue.
well, yes, the position of Mr. Bradley is that his trial attorney requested it, and that should be enough. Not that she never said, I agree with it. There may have been some sort of okay, as if, okay, I'm hearing you. It doesn't mean, okay, I agree. I'm not, the trial.
Well, he never objected.
You don't, my position is that you don't have to formally object.
Well, he asked for a Downs instruction, and the judge says, I'll give it when I get the note from the jury, which you inevitably get in these cases, saying, what about the breathalyzer? Then I usually give the Downs instruction. I'm sorry, she says, okay. I mean, so how would the judge know that she wasn't totally okay with this idea that we'll give it when it comes up? It'll even have more impact at that point.
Because she asked. Being a trial attorney myself, I can tell you that, you're up in front of a judge, you're asking for something, the judge responds. I mean, my practice is now to say nothing, because if you say okay, which is sort of a natural inclination, like, got it, would that have made a difference? I suppose if she said, understood, would that have been,
Well,
I mean,
if
she's
the
not
judge,
saying.
if the judge had said, not given that, I don't give that instruction, then the okay would seem like an acquiescence okay. But when she says, I will give it when we get the question, which we'll get, for sure. Now, that prediction was completely wrong, but, I am going to give the instruction at a different time. Why wouldn't she think that that was acceptable to the defendant?
Well, I guess my response is then, at what point can a response just be, do you have to object after specifically making that request? And
Yes.
Well, I'd suggest that that's not true in my understanding of the state of the law. I cited a case, Rosario, in the SJC, and also an Arias case in the appeals court, where I believe the law states that denial of a defendant's request obviates the need to formally
But she
object.
didn't deny it. I mean, that's the problem. If she'd said, no, I won't give it, that'd be one thing. But
But
she said, I will give it, just at a different time.
She did deny it, though. She effectively denied it by not giving it. She said, whatever she said really, I guess, matters less than what she did. her actions or even her saying, I'll do it, but I'll do it later when the jury inevitably comes back, or when they come back. They didn't come back, so she didn't give it. It was specifically asked for. And I guess beyond, so that's my position on that she formally
But at that
requested.
stage, that charge was not a required charge to be given.
It wasn't a required charge, but it was something that Mr. Bradley's attorney had asked for at the time.
Which doesn't make it reversible error that she didn't give it.
No, but the whole reason I think for the Downs instruction is that the appellate courts understand that juries, the whole Downs decision, that juries kind of understand that most OUI cases, there might be a breathalyzer test. It's common knowledge. And so, there is this Downs instruction that exists so that in appropriate cases, that the juries can be instructed that they
There's
should
also the
consider.
reverse side of that it highlights the fact that he didn't take a breathalyzer.
I'm
Or
not
that
sure.
there's no submission of a breathalyzer, so he mustn't have taken it. It cuts both ways, the charge.
It could. Personally, I don't like it. I don't ever ask for it in my cases. But I guess I could see there's an argument to be.
So there's no
made.
requirement at that point in time when that judge was required to give it under any circumstances.
But that's not the issue. It doesn't have to be required. I'm arguing that if it was a preserved error, something that was clearly requested and denied, then it's a prejudicial error standard, and then this court would have to find that the error is non-prejudicial only if the court is sure that the error did not influence the jury or had but very slight effect. And I suppose that I'd go back even to the Downs case, that the fact that this instruction exists is because the court has recognized that there's common knowledge, and that, I guess I have to tie this into this Wolf decision. I haven't made it to that point, but the Commonwealth actually had asked for a stay, and it was assented to, and this case kept on going for a while. But the Wolf decision suggests that a defendant should have the right to decide whether or not an instruction is given to the jury about the absence of a breath test. I think this is exactly a case on point. Like, maybe I wouldn't give it, but this trial attorney at the time obviously thought it was a good idea and requested it.
I don't know that you need Wolf, but if you do, what's your best argument that it applies to a case that was that happened before Wolf came down?
Well, this case was pending at the time. I actually don't know. It's not. I guess it's not explicit whether it.
Wolf says in footnote 12, our decision today is procedural only and has only prospective application. But then they apply it to Wolf.
They applied it to Wolf, which was a case that happened before Wolf, and this case was already pending. And so, prospectively, I guess I'd say, well, this case is pending before this court, and so that this court should follow suit and follow what the SJC did in Wolf, and apply that standard. We're prospective. We're forward from where that decision was. This court hasn't made a decision.
Is this a constitutional rule, though, that was announced in Wolf?
I don't know that that's.
Because we have one set of rules for of what happens to a case pending on appeal, depending on whether it's a constitutional issue or some other kind of issue.
I don't know that I have an answer for you on that.
Okay. It's not easy.
I don't want to waive that issue, but I just don't know that I have a good answer for you on that.
Okay.
But for all those reasons, I'm asking that the court vacate Mr. Bradley's conviction, and I'm happy to answer any other questions, but if there's no questions, then I would just rest. Thank you very much.
Good morning, and may it please the court. Gabriel Pell, Assistant District Attorney for Middlesex on behalf of the Commonwealth. Commonwealth is asking the court to affirm the defendant's conviction of operating under the influence as a second offense. As a first kind of housekeeping matter, I would note for the court that defendant has moved to withdraw the second claim in his brief regarding jury waiver colloquy, and I would ask the panel to allow that motion, which would leave only the Downs issue for the court's consideration. And I would like to jump right into the last issue the court was discussing, and no, this is not a constitutional rule in Wolf. Justice Budd said explicitly that although this has constitutional concerns underlying it, this is not a new constitutional rule. Instead, this is a rule of procedure that the court was announcing under its superintendent's power. And Justice Sullivan is correct. There are different standards of retroactivity depending on the source of the rule. And I would direct the court to Commonwealth versus Dagley, SJC opinion from 2004, that in the discussion and in footnote 10 kind of explains that if it is not a constitutional rule, where if it's a new constitutional rule, it does apply to cases pending on direct review. But if it's not, if it's a rule announced under the superintendent's power, for example, then the court decides whether it's retroactive or prospective. And when it's prospective, Dagley says that means to trials occurring after this date.
But another thing that Wolf says on page 150 is, because the defendant objected at trial and argued for this rule on direct appeal, he should have the benefit of its decision. Now, I understand you challenge whether it was preserved at trial, but if it was, why wouldn't that apply just as much to Mr. Bradley?
And I would direct the court to Commonwealth versus Smith and SJC opinion from 2015. And what it explains is the adjutant rule, which is what Justice Budd cites immediately after the portion you just quoted, Justice Didkoff, is that typically the default rule is that when the SJC announces a new rule of procedure, it is prospective only, and even the defendant who brought it to the court's attention does not get the benefit of that rule. There is an adjutant exception, which was in the case of first aggressor evidence. The SJC said, this defendant pressed for an appeal, and it was paramount in his case. So we were going to make an exception for the first time ever and give it to this defendant.
But in that case, Pring-Wilson also got the benefit of it.
And
but he had preserved it at trial and preserved it on appeal.
And Pring-Wilson actually got the benefit because a Superior Court judge on a motion for a new trial said it would be in the interest of justice to give it, and it went up to the SJC on abuse of discretion standard. And again, the cases that repeat it say this really isn't how it's normally supposed to go. This is an exception. And oftentimes the defendant who brings the issue to the SJC does not get the benefit. That happens when they change the reasonable doubt standard in Russell. It happens in the extending the age of the interested adult in Commonwealth versus Smith, the defendant who brought it to their attention. And again, Dagley explains that when we say prospective, sometimes the SJC is clear. They say to trials commencing after this date. But if they don't, prospective generally means trials commencing after this date. And to get the kind of adjutant exception, it has to be not just preserved, but paramount. And Pring-Wilson was standing in the shoes of adjutant. He was virtually identical. And this defendant could not possibly state that he was virtually identical to the defendant in Wolf. The question before Wolf was different. Wolf got an instruction that he didn't want it. And a suggestion was put into the minds of the jury. This defendant, it can't possibly be paramount because the jury just didn't hear anything.
Just to go back one more time, when the court in Wolf says that this is a procedural rule, do you understand that to be a rule that derived under their jurisdiction under chapter under 211.3, or is it a common law rule?
I don't believe Justice Budd cites 211.3, but she says our superintendent's power, so I'm saying it's 211.3. Okay. And the adjutant line that she cites later for giving it to the defendant Wolf is in that line of cases. I think they sometimes call it a common law rule of procedure, but no, it's not under the constitutional line.
So do you think in a trial today a defendant has a right to a Downs instruction if he wants it?
I don't think you can get that from Wolf. I think the question presented in Wolf was whether or not it should be given over a defendant's objection, and we now know that generally a Downs instruction should not be given if the defendant doesn't want it. The SJC was not asked, and so they didn't really directly address whether a defendant should get it if he does want it. And I think there are some lines in Wolf.
Regardless of whether you can get it from Wolf, do you think that's the rule now?
I don't think that's the rule. I think, so I would just say there are a couple points in Wolf where Justice Budd characterizes the majority's conclusion in rather broad and I would suggest imprecise language, but you can't look at those lines in isolation. You have to look at them properly in the context of the opinion as a whole. And if you really just look to the first paragraph of Justice Budd's opinion, what she says is she frames the question presented and the conclusion. She says, we're asked to decide whether a judge can give the Downs instruction, and we conclude that it should not be given over the defendant's objection. That's the narrow, precise conclusion in Wolf. And I don't think there's any reason to believe that a defendant based on Wolf can insist on a Downs instruction. And the reasoning underlying Justice Budd's opinion, which the rule is prospective, going forward, a defendant will have a right as a matter of Wolf to veto a Downs instruction. But the reasoning suggests why Justice Forts in this case did not abuse her discretion. Wolf points out first that the Downs instruction is risky. It's kind of a dangerous instruction. It can focus the jury's attention on a matter that they might not have been thinking about, and thereby prompt them to do the exact opposite. And the risk of speculation here that there isn't a breathalyzer, it's not unilateral. Wolf recognizes, and Downs had recognized before it, that the risks of speculation are actually bilateral. The Commonwealth can be prejudiced by having the jury thinking about a breathalyzer and wondering whether it was given, why it isn't there, why it's not in the evidence. Where the risks of prejudice are bilateral, it doesn't make sense to vest the defendant with a unilateral, unqualified right to insist on the instruction. It might make sense to give him a right to veto it, but he shouldn't have the right to decide whether the Commonwealth should also have to run the risk of adverse speculation. Where there are risks to both sides, judges should be able to rely on their traditional discretion in framing jury instructions to determine whether, in light of the state of the evidence and based on the input of both parties, if a Downs instruction is appropriate. And again,
So what do you think about note 13? I mean, I don't expect, oh, do you?
I do.
Oh, okay, great.
I think that means actually that Justice Forts arguably was too willing to give the Downs instruction, because Justice Budd in note 13 says, even if the jury comes and asks a specific question about missing test evidence, the better practice is to just rely on the general instruction. And that was actually going to be one of my next points is, we've established Wolf suggests that it's a risky instruction. It also shows it's an unnecessary instruction. What Wolf says is that if you follow the traditional presumption that a jury is going to follow the general instruction not to speculate, the need for Downs dissipates. And so here, Justice Forts did use the general instruction not to speculate, so the jury was adequately directed not to engage in speculation or guesswork or consider any information outside the evidence. Judges have that discretion to determine whether they should instruct generally or specifically, a general instruction not to speculate or an instruction not to speculate about any issue in the case. They don't have to use the words the defendant requests or emphasize any of the facts that the defendant would wish emphasized. And as the panel noted before, the Downs instruction has never been mandatory. It's permissible, but it's never been mandatory, and it's not mandatory now. And I do think that footnote 13 suggests that Justice Forts was maybe, arguably under the reasoning now, too willing to give it, but she certainly didn't abuse her discretion, and her decision was well within the range of reasonable alternatives. And it's important to note she prevented breathalyzer speculation from being needlessly injected into the trial. That's why there's no Fifth Amendment issue here, and that's different from Wolf. The jury didn't hear anything along the lines of Commonwealth versus Zavitas or opinion of the justices that would have directed their attention to breathalyzer evidence.
Why isn't their request for the instruction a preserved error?
I don't think it's preserved, and I'll say at the outset, I don't think the standard of review matters much here. It could matter in the kind of adjutant Pring-Wilson context that we were discussing, but I do think it's important. It's not preserved, and I would direct the court to pages 100 and 101 of the transcript, which is addendum 5 and 6 of my brief. And in the middle of 101, after hearing from the defense counsel and the trial prosecutor, Justice Ford says, okay, so I wouldn't give it, but I'm on record as saying if we get a question from them, then I'll give it. Okay, question mark. Defense counsel, okay. From this, there would be no way for Justice Forts to know that the defendant was dissatisfied with her proposed resolution of the Downs instruction, and there's also no indication that she wasn't open to continuing the discussion and potentially reconsidering her position. I think that it's not an outright denial, and that makes it different from the general rules that the defendant has cited in his reply brief, that when a jury instruction is requested and denied, you need do nothing further. But this left the possibility that the instruction was going to be given. And it's not about objecting at the close of the charge, it's about objecting right there or saying something where there's that invitation, okay, question mark, even something as simple as, please save my rights or please note my objection. That doesn't happen here. There's a reasonable acquiescence in the proposed resolution. And Rosario doesn't change that. Commonwealth versus Arias doesn't change that. In fact, in Commonwealth versus Arias, the majority said that the objection wasn't preserved, even though there are written requests, save my rights.
What about Grady and Almalay? I mean, those are.
I'm not familiar.
Those are slightly different contexts, and
I'm
that
not
may
familiar.
not be a fair question.
I'm not familiar with the facts of those two cases, but even Biancardi, which the defendant cites, is a case where there was an instruction, the substance of which was mandatory, and the judge kind of proposed an alternative. This instruction is not mandatory, and more importantly, in Biancardi, there's no indication that counsel agreed with the proposed resolution. I think if you consider this preserved, it means defendants can't really request an instruction, and then in light of a very reasonable back and forth, conclude, you know what, it might not be the right time to give it, so I agree. And it also means that they can have it both ways. They can go along, and if it doesn't work out for them, challenge it on appeal and claim it was preserved, even though they went along. So I don't think it's preserved because of that back and forth. But I think regardless of the standard of review, there's no abuse of discretion here, no error, so the standards by which we review error aren't particularly relevant. I also think even if you assume for the sake of argument that Justice Fort should have given it when it was initially requested, the defendant can't show prejudice here. There's just no indication whatsoever that the breathalyzer was a factor in the jury's deliberations. This was a particularly strong case for the Commonwealth. There was a crash into a snowbank at 2:30 in the morning, a fact which alone under Commonwealth versus Hilton and Manning in this court's unpublished opinion in Page can give rise to an inference that the driver was impaired. The arresting officer noted a strong odor of an alcoholic beverage from the defendant, an odor of alcohol from the car. The defendant initially failed to comply with request to produce his license. His speech was slurred. He admits to drinking earlier, has difficulty getting out of the car. He's unsteady on his feet and he's swaying. He takes 2 field sobriety tests. The alphabet test he performs poorly, slurring his speech, pausing to think of what letter comes next, and he fails the walk and turn test, swaying, stepping away, and stopping after a few tests. Plus, the arresting officer testifies to his opinion that the defendant is intoxicated. Faced with this overwhelming evidence, there's no reason to think that the jury was going to speculate about what else was missing that might have supported these charges. The charges were well supported. There's also no testimony whatsoever about arrest or post-arrest or booking procedures, the time in a case where arguably a jury might be most likely to speculate about the deployment of a breathalyzer. Consistent with all that, as we've noted, the jury never asked about the breathalyzer, which I think is also good evidence that it wasn't a factor in their deliberations, and that quite possibly is because they were adequately instructed not to speculate about anything else. And so I think with all that, Justice Forts did not abuse her discretion. Don't think the rule in Wolf, whatever it is, doesn't apply in this case, but it also doesn't give the defendant a right to insist on the Downs instruction. And for those reasons, I would ask the court to affirm the conviction.
Thank you. All right.
Thank you.
Thank you very much. With that, we will take our mid-morning break and be back in approximately 15 minutes. Let me correct the historical record. It appears that long ago, before the current members of the court, we did have the wonderful opportunity to sit in Fitchburg. Those of you who may remember Justice Andre Gelinas, he would not have allowed us not to sit in Fitchburg. And we hope to follow in his good footsteps and be back more frequently. So without further ado, we'll go on to the cases for the afternoon. And the first is HG versus PG.
May it please the court, Andrew Piltzer-Cowan on behalf of the appellant PG. And
Just so it's clear, the opposing counsel has not filed a brief nor chosen to argue any points.
that's correct, Your Honor. In fact, she sent a letter to the court a week or two ago indicating that the appellee takes no position on this appeal.
And this was a restraining order case involving a husband and a wife.
That's correct, Your Honor. So before the court today, we've raised two issues in our brief: whether the evidence before the district court was insufficient to meet the plaintiff's burden of showing abuse as defined in Chapter 209A, Section 1, and whether the district court judge violated the defendant's right to due process by announcing that she had already decided the case before the hearing began. I intend to focus my arguments primarily on the first point, and we'll address the second point briefly unless the court
Let me
wishes to
ask
spend
you
that
this.
time
What,
otherwise.
in your brief, you seek to have the order vacated and law enforcement notified to remove it from their records.
That's right, Your Honor.
And that's been done.
It has been.
So why isn't this a moot case?
Your Honor, I believe the case is cited in my brief, and I apologize for not having it off the top of my head. The appeals court has previously held that when a 209A order that has been issued after a two-party hearing is later vacated while it's pending on appeal, that the appeal is not moot. The only case I know of to the contrary was a case of an ex parte order that was not renewed at the two-party hearing. And the appeals court has held that there is no appeal from the ex parte order when it's not renewed at the two-party hearing. And that's because of the collateral consequences that can inure to the defendant from having a 209A order having issued against him. It is, I believe, still going to be on his carry if he were ever to be charged with a
Well,
crime.
there's nothing we can do here that takes it off the carry. You're not asking for an expungement. That's not part of the record.
We're not asking for an expungement, and we're not, and frankly, I don't think under the existing case law we would have grounds to request expungement.
So there's Allen versus Allen, which is an appeals court case that suggests that was one that was not extended and it was vacated. And they said that unlike a case that has expired, would be moot, whereas an expired case would still be in the possession of law enforcement records. So the stigma would be eliminated once it's removed from law enforcement records.
I should say, Your Honor, although this order was ultimately vacated by a joint request after the appeal was docketed and I believe before it was briefed, I don't think the record is crystal clear that law enforcement has been notified to destroy records, as would be the case if it were, if it had not been extended at the two-party hearing, or if it were to be vacated on appeal and that judgment to
Well, I'm looking at the appendix R13 that says prior court order terminated at plaintiff's request. The court's prior order is terminated. Law enforcement agencies shall destroy all records of such order, and it's signed by the judge.
Right. So that this is an issue I've encountered before in terms of when you have a standard court form with a checkbox that indicates multiple different things, so the order's to be vacated, law enforcement's to be notified, and a clerk checks that box. I think it's not always clear that all of the things encompassed by that checkbox have in fact been ordered by the judge on the record or have been performed by the court. I understand there is a presumption of regularity that attaches to the docket sheet, but I don't think it's crystal clear.
But I'm just asking you, what is it that you seek to obtain from the appeals court that has not already been done in the trial court?
I think what we seek from the appeals court is a legal determination that the facts alleged at the 209A hearing were not sufficient to support the order that existed in the first place. So
To what end?
I'm sorry?
To what end? To vacate the order, which has already been done? To remove it from law enforcement records, which is, there's an order of the court. I mean, you could seek to enforce it.
Right. I think from our perspective, as of now, there is a docket sheet on file in the district court, which is a public record, that indicates that a justice of the district court, after a two-party hearing, found that the allegations submitted by the plaintiff were sufficient for a finding of abuse against the defendant, and issued an order which was only later vacated because the plaintiff agreed that she no longer wanted the order. And if this court were to order that judgment reversed, and if that were then to be entered on the docket, then my client would have the full court record indicating that that determination of abuse by the district court judge was legally incorrect.
Right.
Turning to the issue, and I think I will have a couple of cases to submit to the court by letter on the mootness issue after this argument. Turning to the sufficiency issue, the facts alleged by the plaintiff in this case, essentially turning to what has the most gravity out of her allegations, is that the defendant egged her mother's car, and that during a text message argument about how to discipline their son when they were not physically in the same place, that she had sent him a text that read, "If you don't listen to me, I will hospitalize our son. It's only corporal punishment from now on." And so I think we need to sort of tease these apart factually to address the sufficiency issue. The statute requires, abuse is defined disjunctively in three parts, but the only part that's relevant here is placing another in reasonable fear of imminent serious bodily harm. The adjectives imminent and serious appear in the statute, and the adjective reasonable has been added by judicial construction for approximately 20 years. So certainly egging the mother-in-law's car at a time when the mother-in-law was not present, it's difficult to see how that would place either the wife or the child in fear of imminent serious bodily harm. that really leaves us, I think, with the text message as the only thing left standing. And it's an interesting text message to analyze. I think if the court, I always like to think about if you were only to read one case to decide this case, which case would it be? And I would direct the court to Szymkowski versus Szymkowski, which is cited throughout the brief, and that is 57 Mass Appeals Court 284 from 2003. Szymkowski deals with a case in which, also arising in the context of a divorce, as did this case, where the father was alleged to have committed various misconduct against his 7-year-old daughter on a ski trip. And the father in Szymkowski, the trial court found, had kicked the daughter while they were in bed together because she said that she missed her mother. When she said she didn't want to go to ski school, he had told her, quitters never win and winners never quit, and threw a milk carton at her, striking her foot. And the father in Szymkowski had told the daughter that he was having a dream in which she was murdered. She had cuffed her on the chin twice. And the appeals court analyzing his conduct says, look, this doesn't get an A grade for parenting. In fact, we consider it unacceptable parenting. We consider it intemperate parenting. But it doesn't rise to the level of serious family violence at which Chapter 209A is directed.
Do you think Szymkowski is still good law, and does it stand up next to more modern appeals court precedent?
I think it does, Your Honor. It's certainly never been explicitly overruled, and I think we also have...
Is that required for us? Or is explicit overruling required, or are we permitted to look at more recent developments in the law?
The court is certainly permitted to look to more recent developments in the law, and certainly it's an appeals court case, so the court can overrule itself now if it chose to. I do think it's still good law, and I think the court also in, so it's about the same era, but Keene versus Gagney 2004, also emphasized the distinction between serious family violence and intemperance or other things that don't quite rise to the level. If you want a more modern case, I would direct the court, the most recent case I've cited in the brief is the 128 opinion just last year, 2017, in KK versus UM.
What about Ginsburg versus Blacker? Defendant's attitude and contact towards her became hostile and increasingly erratic. He's right up in her face, screaming and waving her hands, had never struck her, but we found enough for a 209A.
So I think the distinction here is that being up in her face, screaming and waving her hands, this turns to the elaboration of placing another in imminent fear of serious bodily harm in light of the common law of assault that the Supreme Judicial Court dictated in Gordon, which was decided in the year 2000. And in Gordon, the SJC says, placing another in imminent serious bodily harm, in reasonable fear of imminent serious bodily harm, has essentially the same definition as common law assault, that it needs to be either an attempted battery or an imminently threatened battery. This court in 2003, Commonwealth versus Chambers, looked at the definition of imminently threatened battery in a criminal context and said imminently threatened battery requires objectively menacing conduct with the intent of causing apprehension of immediate bodily harm. So the case you cited, Justice Ditkoff, I think when you have somebody who is standing in another's personal space, acting, we might say, unhinged, waving his arms and screaming, that could place a person...
Which he was doing to the grandmother, to the plaintiff's mother.
And so if the plaintiff's mother were the plaintiff in this case, I think that conduct would be analyzed differently. But the question is whether the plaintiff and the party's minor child was placed in reasonable fear of imminent serious bodily harm.
So she has this man who she's married to, and he's in her mother's face. She's threatening to hospitalize the son, and I look at the affidavit. He breaks lamps, cologne bottles, slaps the face of the child, drinks alcohol almost every day, grows increasingly irrational and explosive. He hasn't said, and now it's going to happen to you, but why wouldn't a rational person in that situation think, this is going to spill over to me pretty soon? That's why he's doing all this in front of me.
So I think I need to answer that question at two levels, Your Honor.
Please.
One is that I don't think the affidavit is properly part of the record at the two-party hearing on which this appeal is based. It was not taken in evidence. It was not offered as an exhibit. And I think the best analogy I can give is if If you had a civil case, just a regular civil lawsuit, plaintiff filed an ex parte motion for an emergency temporary restraining order supported by an affidavit. That order issues. There's then a contested hearing 5 days later, at which nobody offers the affidavit and evidence, but the plaintiff testifies. And then the defendant takes an appeal from the preliminary injunction. The affidavit that supported the ex parte TRO would not be part of the record on appeal from the later preliminary injunction.
But didn't the judge say she was relying on that affidavit at the hearing? Didn't the judge indicate that she was familiar with the case, she had the affidavit, and was there anything else that they wanted to add?
And so this takes us to my second issue, Your Honor, which is that in fact at the outset of the two-party hearing, before either party had offered any evidence, made an opening statement, or really said much of anything about their position, the judge said, well, I've read the affidavit, I heard the ex parte hearing, I have enough to make my decision, does anybody want to be heard? And this really turns due process on its head.
But beyond the due process issue, is there reference to the affidavit by the judge or can we rely on that as she has made it part of the record in the hearing?
I understand the question. I hesitate because I don't have a case off the top of my head to answer it. I'd like the answer to be no, as I'm sure nobody is surprised by. I would point out that none of the facts Justice Ditkoff noted from the affidavit just now, none of those facts were in the plaintiff's actual testimony in either hearing. She wasn't directed on it, she wasn't crossed on it. It just didn't come up. And I think that is of some note. The other thing that I want to say...
Although if the judge says I have the affidavit, any reasonable lawyer or litigant might think that they don't need to restate all of those facts again.
They might. I mean, I think it's common in my experience for judges at the commencement of a hearing to state that they have the papers, that they're familiar with the papers. I don't think that necessarily means that whatever papers they've reviewed are in evidence at the hearing. With a minute left, I do want to turn to one other answer to Justice Ditkoff's question about why wouldn't a reasonable person think I might be next. And I think the answer lies within the adjective imminent in the statute, or immediate in Chambers, that it can't just be something bad might happen to me in the future. If there hasn't been an actual or attempted assault, which is the first prong of the statute, if we're just dealing with the fear prong, it has to be imminent fear. And if she wants a more immediate remedy before that imminent fear comes into play, she can go to the probate and family court and seek temporary orders on a complaint for divorce or for separate support. She can seek a remedy there. But formalistically, we are dealing with the legal requirements under Chapter 209A, Section 1 to issue an order under that statute. And there is a historic, statutory, and common law requirement of imminence in that context.
Just to tie up a loose end, you indicated you would submit a 16L on the mootness issue.
On the mootness issue.
Is 2 weeks sufficient?
2 weeks is sufficient. Thank you.
All right, thank you.
Thank you. The next case is 17P0706, Cahalan versus Skydive Cape Cod, Inc. You may proceed. Oh, and I gather the defendants are splitting time. 7 and 8 minutes. This clock won't do 7.5. Thank you. All right.
Good morning. If it pleases the court, my name is Edward Bassett. I represent the plaintiff and the appellant, Tricia Cahalan. On July 25th, 2012, on her 32nd birthday, Tricia Cahalan decided to celebrate by doing a tandem parachute jump. This is the same type of tandem parachute jump that former President Bush at age 90 did, where you are jumping out of an airplane, but you are in the lap of an instructor. Before selecting the Chatham Airport, she researched and determined, based on their website, that this was the safest of all drop zones, and that the drop zone complied with all USPA rules, recommendations, and it was an official USPA drop zone. When she gets there, she signs a contract, and it is a contract, not just a waiver, And the contract says on the first page, in the largest print there, we, the defendants, will do everything in our power to make your jump as safe as possible. Surprisingly, my brother, on page 44 of his brief, Attorney Lawless, says, defendants say there is no evidence of any express representation that the defendants would do everything in their power to guarantee her safety. So I refer the court to page A00180 for that language. The waiver itself was the wrong waiver. This particular company had two operations. They had one in Barnstable or Marston Mills, and they had one in Chatham. They had separate waivers for each airport.
Was this issue raised that you're just addressing right now, was that argument made before the motion judge in the trial court?
Not specifically, Your Honor, but it was in the record, and it was raised in terms of, we said there was lack of consideration, that it was an illegal contract because they had been kicked out of that airport, and therefore any waiver that referenced that airport would be illegal.
But the argument that they didn't name the right airport was not made.
Right.
And our normal rule is arguments not made below or waived.
Well, if the court chooses to ignore
Well,
the contract, the contract itself is the wrong contract.
I appreciate the argument. I'm just trying to, you've got limited time, so.
Right, thank you. All right. So, what did she sign? She signed a waiver, but what did she not agree to? She did not agree to have an instructor who had falsified his logbook, and there's testimony of that. She did not agree to have her instructor perform a hook turn, which was specifically prohibited by the USPA, specifically prohibited by the manufacturer of the parachute, and specifically prohibited by the airport itself. She didn't agree to jump at a drop zone that claimed to be USPA sanctioned, where that drop zone did not have a safety director for 2 years. So there was no one there to report these safety violations and no one to report any of the accidents. She did not agree to jump in gusty winds of approximately 30 miles per hour when the defendants themselves had concluded that it was unsafe to jump that day, and there's testimony there.
Before you go any farther, one of the procedural questions before us, and I very much appreciate your recitation of the evidence, and it's also, I'm sure, very helpful for the people who are listening. But I'm hoping that you will address the arguments that have been made by the defendants that certain evidence should not be considered, and specifically, the judge found that an affidavit that your client offered on summary judgment was not to be considered because it hadn't been produced in discovery. And as I'm listening to you, I think I'm hearing some of the things that may have been represented in that affidavit. So I think it would be helpful if you could address that issue up front as to whether or not, A, was that document produced in discovery, and B, if it was not, why did the judge abuse his discretion in excluding consideration of that affidavit?
Yes, Your Honor. First of all, I think the facts in that affidavit, you could ignore all the facts of that affidavit, and based on our experts' opinions and based on all of the other evidence, testimony, there's plenty there to show gross negligence.
Right.
However,
as to Silva and others there, but that affidavit I also understood to be particularly addressed to Howard and his employer,
right.
Which I'm not sure that you can address whether or not the expert also gets you there with respect to those defendants.
Will do. All right. So I would submit that Judge Curran did abuse his discretion, and he abused his discretion. Every motion for summary judgment gets filed by one side. The opposing side files affidavits. That's what I did. There was a request for all statements, which we objected to and said, this is work product. So
Is
the
that
plaintiffs,
objection anywhere in the record?
Sure it is.
Where in the record is it?
Well, it's in my response to the request for documents.
I know, I was looking for the response for request. It's a voluminous record, but if you can have a permission to file a 16L letter and point out to us where that is, because unfortunately the brief does not have those kinds of citations.
Right. So, Your Honor, at her deposition, Tricia Cahalan testified months before that she spoke with Seidowitz and that Seidowitz gave us an affidavit. They knew that. They
And her
didn't-
May 6th deposition, and then
Yep.
in June, they gave you a request for production.
Right, right. They never followed that up with a motion to compel. They knew that we had the affidavit.
Are
They
they-
didn't pursue it. So it's much too harsh a sanction for this court to look back and determine whether or not they should have filed a motion to compel. You would be imposed.
Was your objection on the grounds of work product before Judge Curran?
Well, he never concerned, nobody raised the issue. Nobody pursued that affidavit. They weren't concerned about the affidavit.
No, but on summary judgment, it was raised. Did the record before Judge Curran have your objection?
Well, if it had my response to the document request, it would, yes.
Well, I would.
it?
But I don't know. I don't know
Okay.
the answer to that, Your Honor. I don't know. However, there was no motion to compel that document. And for the appeals court now to say, well, we're going to go back now and say that you violated a court order, we didn't. We disclosed the fact that there was an affidavit at her deposition. We disclosed the fact that Mr. Gustavo had an affidavit. And so what did they do? They deposed him, and they looked at the affidavit. They had 7 months between the time that we filed that affidavit and the hearing within which to, under Rule 56, say, gee, we need to depose this person, or whatever. They are trying to go on my back, having gone and taken a statement from that man. That's work product. It's the purest form of work product.
What is your, I noticed that in your brief, but I didn't see any citation to authority. What's your best authority for the notion that a fact affidavit, which you have produced in the context of summary judgment, is work product?
Well, Your Honor,
Not subject to
I've written articles
disclosure.
on that. I have plenty of cases to submit. If you would give me 2 weeks to do that, I'll send you everything. That a statement that a lawyer goes out and gets from a witness, a plaintiff, that's my work product. They have the absolute right to go and take a statement from him or take his deposition. There's nothing that I withheld from them that they couldn't get on their own.
Except the state.
Well, why didn't they subpoena him in the statement? They had 7
Well,
months to take his deposition. Every time someone files an affidavit in a motion for summary judgment, are you saying that that should be excluded because it surprised them?
I'm asking you for your authority.
Now, I'll give you my authority that that is pure work product. That's probably the purest work product that there could be, is me going out and taking a statement and recording that statement. Now, as far as Howard and Cape Cod Flying Circus go, they deny they had any duty whatsoever. However, they're trying to benefit from the signed contract that says, we will do everything in our power to make your jump as safe as possible. What did Howard and Cape Cod Flying Circus do to ensure? They say, we did nothing. We had nothing to do with that operation. We didn't check the winds. We didn't even know what a hook turn was. We didn't do anything. Well, what was your obligation under the contract? Under the contract, I was obliged to observe and determine whether or not there were any violations.
Flying Circus didn't sign this contract.
No, none of the defendants signed the contract.
Well, there's a staff member who signs it at the bottom,
Yep,
who I assume works for Skydive Cape Cod,
right.
but no one who works for, this isn't a contract between your client and Flying Circus.
Well,
It benefits them, but it doesn't, they're not the party to it.
well, in the contract itself, it defines Skydive Cape Cod as including all of the named defendants.
Where does it do that?
Where their names are in bold print, it says hereinafter Skydive Cape Cod includes all of these defendants. I mean, but
I don't see
furthermore,
that. I see them as a party released from liability.
yes, and it defines them as,
Right, the term Skydive Cape Cod Inc. is in this contract will then incorporate that, but you can't make someone a party to a contract that way.
like Donald Trump. You can't make him a party to the contract when they say they're trying to seek the benefit of the contract? And there are affirmative duties that they have to perform, which is, we're giving up our right against them, even though they've affirmatively stated that they'll do everything in their power to make it as safe as possible?
I mean, I could write a contract defining Judge Didkoff as including you, but that wouldn't make you a party to the contract, even if it benefited you.
Well, it's one thing if you're a third-party beneficiary, like in a life insurance policy, but that beneficiary has no affirmative duties. But here, there are affirmative duties spelled out in the face of the contract that says we will do everything in our power to make it safe. But beyond that, I would point out that the law states that a waiver is unenforceable for violation of statutory duties. And Mr. Howard was the statutory airport manager under Chapter 90, Section 51E, has statutory duties. And he specifically, according to my client's deposition, he was warned by Gustavo, you gotta stop these hook turns, somebody's gonna die. So there's direct evidence, not just from Seidowitz, but from Tricia's testimony, that this is what was told. Someone's gonna die if you don't stop doing this, because this is horrible. And also, he had been warned that this particular outfit had been shut down by Mass Aeronautics and Marston Mills. He admits
That warning coming from Gustavo or from Seidowitz?
That warning came from Seidowitz.
Right.
And
The Seidowitz affidavit was not considered by Judge Curran. He
Right.
puts that in a footnote. Was there any other affirmative action by the judge excluding it from the record in any way?
No.
Striking it?
No.
Or finding that it's not admissible because of late disclosure or anything of the like?
Right, thank you, Your Honor. There were no motions to strike any of the affidavits, none. And
Including Gustavo's?
including Gustavo. Gustavo's affidavit
So-
was attached to his deposition, which he said, I read it, it's correct. I read it over and over again, it's correct.
It was made an
Correct.
exhibit in the deposition, correct? Yes.
All right. And for purposes of our standard of review, do we review Judge Curran's decision excluding from consideration the Seidowitz affidavit? Do we review that for abuse of discretion, or do we review the record de novo?
You review the record de novo. Every time the appeals court, there's no weight given to Judge Curran's decision under the law.
Well, if he had excluded them on the record in some fashion, like make a decision on an evidentiary issue of late disclosure or a decision on a motion to strike, we might have to review that for abuse of discretion. But that
Right.
wasn't done here.
Right.
So your position is we review everything de novo, independent of whether he didn't consider it or not.
Yes, you are.
All right.
Thank you. And as I said,
And just one last question on this procedural point, because I think it's important, which is, were the defendants obligated to bring a motion to compel? Or could the judge have properly simply taken the argument which they made in the course of the summary judgment proceedings without a motion to compel?
I say that they would have had to file a motion to compel. They knew of the document. It wasn't a document that was concealed. She testified at her deposition. We have an affidavit from him. They didn't take a statement from him. They didn't take his deposition. They didn't move to compel it.
I realize that your red light is flashing.
Okay. Thank you, Your Honor.
Yes, may it please the court. Attorney Robert Lawless on behalf of Cape Cod, Skydive Cape Cod, and also Jimmy Mendonca and Marcus Silva. Picking up from where the court left off on this issue of the Seidowitz affidavit, I direct the court's attention to that footnote in the court's decision, which is on my addendum, page 5, where the court says the court agrees with the defendants that consideration of this affidavit would be unfair to them, where they requested information about Ms. Cahalan's communications with and the documents related to Mr. Seidowitz in June 2015, mindful that that affidavit was signed in December of 2014.
What do you suggest that means?
Well, he goes on to say that the affidavit was responsive to the defendant's document request, but was not produced until the summary judgment stage.
Are you
It put-
suggesting that's a ruling on an evidentiary issue of to exclude or strike?
I think what it ultimately goes to is the standard that a summary judgment judge is looking at is the question of whether or not there is a reasonable expectation of proving elements of gross negligence, ultimately.
But if
Reasonable
we consider that affidavit,
If you do, yeah.
we can do it de novo as compared to finding any abuse of discretion on that part of the judge.
Well,
That's a question, not a statement. I'm
correct.
asking.
And I hear the court, and I would suggest to you that that's exactly what Judge Curran was suggesting, is that it would be unfair to us, because we, the defendants, didn't know about the affidavit other than reference to it in a deposition. Then you send out a request for production. They never produced it, and then suddenly.
Is it true though?
Go ahead.
Is it true though that they said, we object, we don't have to produce that for you under work product?
I honestly do not recall as I stand here now whether that was their objection. I simply know that Judge Curran, when we brought this to his attention, ruled at the time of summary judgment that it should have been produced. To some degree, I think that that's a ruling that it was not privileged, it was not under any kind of work product protection.
Did the record before Judge Curran contain their response to your request for production?
It contained this affidavit. It contained, is that your question?
No, I'm asking, did it contain your request for production and their response? I see your request for production in the record
materials.
here. I had
Correct.
difficulty finding a response, which led me to question whether or not a response containing an objection was before Judge Curran.
I do not recall that that document was handed, certainly was not part of the summary judgment documents that were handed to the court. But we were caught by surprise at the time of
Well, the issue of surprise all depends on whether or not there was a response with an objection.
correct. Well, and
Which
even if we
leaves us in a
objected-
bit of a quandary because we don't have a record of it.
And my suggestion
Or if we
to
do,
the
I
court-
haven't found it.
Correct. And my suggestion to the court is twofold, and one is that we can even go beyond the Seidowitz affidavit. But let's stay with it for a second.
Okay.
Because I believe that it was inappropriate for him. They held the affidavit in December of 2014, if I have the date right. Yes, and then the request for production went in 15. He should have responded to that or indicated that they had, because you can't simply say objection. You have to say, we are holding an affidavit under the rules now exist for discovery. You have to give a detailed explanation of what it is that you're objecting to and the basis for it. That was never given to us. And then it was a surprise only in the sense that nobody had seen it before until he suddenly filed it. And all of us raised that issue at the time of the summary judgment.
But
and that's
none
what-
of you moved to strike that affidavit.
Well, there's a question about, and I'll direct the court to.
Well, let me ask you this. Was there a
Yeah.
formal motion to strike on the summary judgment record?
And I'm
And
going to
a
say.
written motion?
And I'm going to say a yes and a no to that. Because, and I just want to direct the court to the attention to the record, volume 5A03081. And that's where there was actually a formal motion submitted, not on the Seidowitz affidavits, but similarly, they had suddenly produced a supplemental response right at the weeks before the argument with their expert opinions.
50,
Sorry, A
3081.
03081.
Yeah.
It's a motion in opposition, and I believe my brother filed one as well. And in those situations, what we brought to the court's attention was that suddenly, that even though expert interrogatories had gone out to the plaintiff, they never disclosed it. Suddenly, 1 week before the argument, well, supplemental amendment.
All right, but what I'm saying is the Seidowitz affidavit was submitted as part of the summary judgment
It was.
package, which was, I'm not sure, I didn't look at the dates, but probably months before any argument.
Correct. That's
And
correct.
no motion was filed to strike that
No motion,
affidavit.
no written motion was filed to strike it. There was an argument made that it should be disregarded.
The argument was made in the summary judgment
Well,
paper.
I think it's distinctive whether it's disregarded by the judge or it's stricken from the record. So if it's on the record, I would suggest the appeals court can review it de novo.
That you could, again, if you find it to be reliable, because we also argue that it's riddled with all kinds of I thought. He was testifying from his airport in, call it Barnstable, what was happening in Chatham on the day of this.
I understand that, but there's nothing in the record that prevents us from reviewing it de novo.
I think not. I think that you could review it to the degree that you're going to find it, to be accurate or reliable, a better word. And the second argument is whether it's fair to us. Because again, we could have, had that been disclosed to us at the time of production of documents, taken the deposition of Seidowitz, and I'll suggest to you that there's a lot more to Mr. Seidowitz, who's a competing airport with my client, and there was absolutely, I can suggest to the court, there's a serious question about whether or not my client was technically fired. My client left for other reasons, but that's a different issue for a different day. If I could just address briefly the waiver issue, I know that you have that in terms of our briefs, but I would suggest to you all that there is no question that a waiver signed under these circumstances by an individual who has a background in law, came to this place, understood what she was signing, wrote in her own handwriting, sat through a video that ran for 10 or 15 minutes, all of which is in the transcript.
Except she loses her deposit if she doesn't sign it.
And that's a choice that she made.
But was there any evidence that she knew that there was going to be a deposit? That she knew she would have to sign a waiver when she...
Sorry. No, that was indicating my time.
Was there any indication that she knew that there'd be, that she had to sign a waiver when she made the deposit?
That specifically was not addressed, but it was addressed at the table that day, where she was told that she would not get her deposit back. But that's a choice that an individual makes. It's not a misrepresentation.
But
I don't see any...
You take someone's money, and then when they show up, you say, well, if you don't sign this waiver, we're keeping your money. Why isn't that unconscionable?
But that's because it's also in the disclosures that you have to sign a waiver when you arrive that day.
Right, but you're gonna take her money if she doesn't sign that waiver right there.
The deposit. Only the deposit, because they've reserved that spot for a particular individual. I don't think that that's unconscionability. And in fact, if you look at the Sharon case,
well, if someone
several of the cases they talk about, the situations where an individual will come and say, you want to play high school sports or sign the waiver? And a person has to make that choice.
But they normally don't say, and if you don't sign the waiver, I'm taking $50 from you.
And that depends on the circumstance. Here, she was pre-warned that this was a requirement that you would have to sign a waiver. It's on the website.
She was. Okay, that's what I was asking.
Yes, correct.
Was there a warning beforehand?
I believe
when she signed up.
I believe it's in the website simply saying you have to sign a waiver.
And speaking of websites, her affidavit contains an Exhibit A, which she says she took from the website. Is there any dispute that that's the website page?
Well, I don't dispute that it is. We questioned for the court that it was not properly presented to the court.
Understood.
And that's a procedural type
Understood.
of issue. But
Understood.
okay.
Okay. Thank you.
Good morning. May it please the court. Nicholas Bart on behalf of defendant appellees Cape Cod Flying Circus and Tim Howard. I'd like to begin briefly, Your Honors, by referencing the waiver that we've just been discussing. There's no dispute the waiver was signed. In fact, there were two separate distinct documents in total of which plaintiff initialed and or signed in excess of 24 times, acknowledging she understood the terms of the waiver and understood the implications of the waiver.
And do you think it's right that before she put in the deposit, she knew she'd have to sign a waiver when she came there?
I do believe that that is part of Skydive Cape Cod's published materials. I would highlight, though, Your Honor, that I believe the court touched on this earlier. My clients have no involvement in the operation of Skydive Cape Cod. There is no evidence of record to suggest that they had anything to do with that operation by way of training, supervision, oversight, sharing of funds, sharing of facilities, maintaining of facilities, or any other involvement with the operation of that separate business entity. That is undisputed. There is no record to the contrary. Plaintiff's counsel, in his argument before the court today, referenced what he perceives to be some duties, and he specifically referenced a statutory duty that my client, he believes, owed to the plaintiff in this case. And again, I would suggest to the court that the record is absent of any statutory duty on behalf of Cape Cod Flying Circus or Mr. Howard to supervise the skydive operation run by Skydive Cape Cod. In fact, included in the record is correspondence from the Federal Aviation Administration specifically prohibiting that activity. The FAA sent a letter saying it would be inappropriate for the airport manager, Cape Cod Flying Circus, and Mr. Howard to assign personnel to conduct oversight or safety evaluations as, and I quote, this responsibility rests solely with the FAA.
So what kind of things happen at this airport other than skydiving?
There's a maintenance facility. General aircraft can be maintained, get repairs. There's a restaurant. There's a fuel depot where the general aviation pilots can go get fuel for their aircraft. All of which these
private craft can take off and land from here?
Yes, they may. And all of those separate and distinct business entities are operated under concession agreements as agreed with the Airport Commission. None of them significantly, as relates to Cape Cod Flying Circus or Mr. Howard, impart any duties for those entities to supervise or observe the activities of those independent business entities. For example, the restaurant operates there. That agreement to allow them to operate at the airport does not somehow transform the airport manager into some duty to supervise or check the temperature of the refrigeration, etc.
Let's use the restaurant as an example, though. If the airport manager were to determine that there were bacteria rampant and unsafe health conditions in the restaurant, would the airport manager have the ability to suspend operation of the restaurant or terminate the contract?
That responsibility does not inure to the airport manager in these contracts. Rather, it rests solely with the Airport Commission. So in that instance, in the example that Your Honor gave, the airport manager would report that instance to the Airport Commission, who then has the authority, as set aside in the contract, to take appropriate action, whatever it deem appropriate.
So is it your position that no matter what the Siderwitz affidavit says, the complaint was made to the wrong, that's immaterial? Because neither Flying Circus nor Howard had the authority to act?
No, in fact, specifically, as I just described for the court, that scenario happened with the Siderwitz information, if you will. Mr. Siderwitz says he came and told Mr. Howard that he no longer allowed Skydive Cape Cod to operate at the Marston Mills Airport. Well, a couple of significant things about that. A, what did Mr. Howard do? He immediately relayed that information to the Airport Commission, as is the limitation of his duties under the agreement. B, he advised that he was unable to independently ascertain the basis for the fact that Skydive Cape Cod was no longer operating at Marston Mills. And at the time that information was relayed to Mr. Howard, Skydive Cape Cod was already operating at the Chatham Airport, had been operating at the Chatham Airport for some time, had never had a violation, had never had an accident or incident, had been inspected numerous times by both the FAA as their sole purview and by Mass DOT as is their purview under state law regulation. No violations had ever been found.
I didn't read Howard's deposition. Are you telling me that he discusses Sideritz's complaint and what he did with it in there?
He discusses generally that he received a phone call. Yes, Your Honor. In his deposition, Mr. Howard testified that he received a phone call from Mr. Siderwitz, who said that Skydive Cape Cod was no longer operating at Marston Mills. Mr. Howard significantly denied that he was advised that it was due to any safety concerns, and in fact, I believe the testimony of record is that Mr. Howard determined that that was what he perceived to be a personality conflict as between the operator, Mr. Siderwitz, and Mr. Mendonca. So as I point out to the court, the record is clear. There is no duty for Cape Cod Flying Circus or Mr. Howard to do anything with regard to the operation of Skydive Cape Cod. It's a simple land rental agreement, nothing more.
If we could just stop for a moment. He did think he had a duty based on the facts that he says he learned. He says he knew only that SCC wasn't operating at Cape Cod. He did feel that he had an obligation to report that to the commissioners.
I don't know that he has a duty to do so, Your Honor. Mr. Howard testified that any time he received any information about an entity at the airport, he would relay it to the airport commission for their determination on how best to proceed, if at all.
All right.
But there's no record that there's a
And if
published duty.
if he had known of the safety concerns, what would your argument be with respect to any duty to report those safety concerns?
Again, I think Mr. Howard...
Because we have disputed facts on that, so we have to take this in the light most favorable to the plaintiff,
Certainly.
which would be that he knew.
Well,
So what would be your legal argument if he knew about the safety concerns?
the only duties that Mr. Howard would have to be derived from either the statute or the contract, and both are silent as to any duties to do anything with regard to the supervision or operation of the skydive operation at the Chatham Airport.
Okay.
Well, wouldn't he have some common law duty to ensure safety at an operation in which he was overseeing the entire airport?
It's a significant...
I understand your distinction, but here he's being told, like Seidowitz would have had the same kind of legal duties, but went beyond that, according to his affidavit, when in Marston Mills, when he talked to Mass Aeronautics and said he was terminating the SCC from his field. He then says he shared that same information. Now, maybe there's not a statutory or contractual duty, but is there an obligation not to turn a blind eye to potential safety violations?
The answer is twofold, Your Honor. One, the record as it stands says that there was no information conveyed to Mr. Howard regarding any problems with safety at the Marston Mills Airport, simply that Skydive Cape Cod wasn't operating there. That being said...
No, but you have to take in the light most favorable to the plaintiff, and then so that means you have to accept as true the Seidowitz affidavit, which is that I told him.
And that being said, Your Honor, Mr. Howard did relay that information to the Airport Commission for determination on how best to proceed, if at all, as is the terminology, or excuse me, the requirements of that contract.
But there isn't evidence that he, as you just noted, that he related the safety concerns because he denies he heard it.
The record stands before this court that Mr. Howard was unaware of any safety concerns. Now, plaintiff's counsel had referenced plaintiff's affidavit of all things, suggesting that Mr. Roque perhaps told Mr. Howard something completely inadmissible hearsay, completely beyond the scope.
I'm not referring to that affidavit, just the Seidowitz affidavit, which would have been the disclosure of safety concerns above and beyond that to which he acknowledged in his deposition.
And any information received from Mr. Sidowicz to Mr. Howard was relayed to the Airport Commission for action.
Anything further? Thank you.
Thank you.
Okay. Our final case of the day is 17P0589, Donahue versus Lamar Industries.
That's not giving me a...
May it please the court, my name is Peter Bossi, and I'm the defendant appellant in this matter. And I guess from the get-go, Your Honor, I do want to point out, I do realize that the standard that you're putting forward, this is an abuse of discretion standard. And I do realize that it's a tougher standard in this particular case, just because the court made a decision with respect to some evidence in the underlying matter.
Would you take a couple of minutes for the people in the room and just 1 minute to just
Sure.
outline what the case is about
Sure.
and the issue?
This case is about a slip and fall on some ice that's covered by snow in a parking lot. And it is a parking lot of a commercial property. It's a very large parking lot. And this case is about a woman who gets into pulls into the parking lot on February 1st, 2011. And at that time, it's about 9 o'clock in the morning. It had been snowing about an hour or so, maybe it just had started to snow. She backs her car into the parking spot. She gets out of her car. She steps down, and she walks into the premises without incident whatsoever. No slipping, no sliding, no falling, nothing. No indication that anything's wrong, any problems, ice, anything like that. About an hour or so later, she comes out of the premises because she forgot, I guess, a clementine or her lunch in her vehicle, and she walks back out, and she walks through the same area, and she gets to in between parked cars, and she steps and she slips and falls on some ice. Now, this case is just simply that. It's a question about whether or not the property owner used reasonable precautions under the circumstances in maintenance of the property. A snow and ice case. That's generally what we're talking about. What the problem is, I see in this case, is twofold. And we addressed three things in our brief, okay? And I'm not going to address the third. I'll let the papers talk about that, the motion for remitter. But there's a couple things that I want to address with the court. Understanding that this is a situation that is an abuse of discretion, we have significant testimony that was let in about prior incidents in the parking lot. And prior incidents, most of which were not even, in fact, I think none of them, were actually reported to our client at all, meaning the property owner. Our client is the one, admittedly, who comes in, he will plow the property, and he indicated he would spot sand and salt the areas that there were issues that he noticed, okay? There was also, so now we have testimony of the course of over 3 years, maybe even 5 years. And the record, you have that in the record, the testimony from these various employees of the plaintiffs, or they're co-employees of the plaintiff, about various nondescript areas in a very large parking lot. And I submit to you, there's no indication at all. It's not the same area where this incident happened. And I suggest to you it's important here. These prior similar incidents, or these weren't prior similar incidents, and letting this information in was abuse of discretion and unduly prejudicial to my client in this case. You know, this is a case and kind of dovetails, because now you have that evidence. You have the evidence of these supposed prior incidents and how treacherous and dangerous this parking lot was. That was the evidence that was let in over objection. Okay? So we have this evidence that wasn't reported, and then we have put on top of that, the court it compounds the problem because of the fact they let in testimony of a meteorologist about drainage issues and ice melt, and I understand it's in there, you'll see it, but you probably have already seen it.
We have?
As far as the Fred Ward, I apologize, but Fred Ward comes in and testifies that, okay, the weather conditions were conducive to the thawing and refreezing of water. Okay, there are snowbanks supposedly on the side. Okay, great. That's within the purview of an expert, especially a meteorologist. The next question becomes, though, is he allowed to testify about the drainage and how water moved across the parking lot and where it ended up when he did absolutely no testing at all? And he admits to this.
Well, didn't the judge indicate that some of that was not even expert testimony? It was just common knowledge, well, and based on observations that even a layperson could deduce or make?
And Judge, he did say that, but I think it's actually something different. Because once you start allowing an expert to talk about that, you give him that indicia of, I've got an expert. And despite the fact the jury instructions at the end, now you've got an expert who's up there with his PhD in meteorology talking about how water moved across the parking lot and how there was drainage on one side and drainage on the other side. But there's no indication about if there were snowbanks there, would the water have actually moved that way? Because if you saw the evidence, there's, I think in the record, there's some photographs of the parking lot. There's actually a aisleway that goes down the middle. So we got snowbanks here, it's plowed. We've got the woman falls over here, the plaintiff, and she doesn't fall in the area of drainage going down here or drainage going down the other side. So
Could the jury have evaluated that based on the evidence that was in the record?
Well, the jury could have evaluated that. That's accurate. They could have.
Because
But-
it does fall within the land of lay expertise in some
Yeah, but
senses.
I
You look
do-
at the photograph, you look at where the drains are, you look at the grade, you imagine the snow, or you look at the snow.
Well, I do think it makes a difference here about the area and the banks. I do think it falls kind of outside the expertise of a lay witness, because if it happened on the side, if it happened where, on the side where the drainage was going down, or in another area going down, I do think that probably falls within the expertise of a lay person. I think here, by allowing him to testify about that, it really was, an abuse of discretion here. So compounding these two different things, now we have the plaintiff talking about, being allowed to put in evidence of prior, what they allege are similar instances they're not the same area.
Well, your client testifies, he doesn't particularly remember this day, but he always goes out 4 or 5 times a day, he gets in before sunrise, stays till after sunset, and he's always on that parking lot scraping it down, not just this particular day or that particular place, but always the whole thing. So why doesn't it rebut his testimony, all these people saying, that's just not true?
Well,
I've seen the lot, contrary to what he said, in terrible shape many times.
Well, because I think here, what you have to take this particular instance, what the plaintiff actually was alleged was this area was unreasonably dangerous because of the way this went down. The water drained into this area, and by allowing some testimony about other unrelated areas, and there wasn't a limiting instruction, nothing on that. It was just this evidence was coming in over my objection. So I do understand what you're saying, but I think this is something that's a little bit different. It's got to be confined to this one area that we're talking about, because their case was about drainage and water drainage and ice forming as a result of that drainage.
It was about the maintenance of the lot as well. I mean, the contradictory evidence was that it wasn't sanded on a regular basis or salted. And that was a big part of their case, that it wasn't maintained properly, not just the drainage, wasn't it?
Well, I guess that is correct, Your Honor, but my position is still that that evidence that was allowed in was really over the top when it came to that particular issue.
You're talking about the expert evidence now, or the prior incidents?
Expert and prior incidents, because it deals with, the testimony was about the office manager to testify, well, there was one time I had to send somebody out and do some sanding and salting in a walkway, which isn't the parking lot, okay? And the areas that...
But it belies the representation that we were always on top of it. We did it all the time.
Well...
And it also shows notice, doesn't it, if the office manager is sending somebody out?
No, I disagree with that, because there was no evidence about, as far as notice given to my client, aside from, there was, and I put it in our brief, it was put in our brief, that our property manager, meaning the owner, was made aware of times during snowstorms where this occurred.
But your client testified that he was inspecting the lot regularly, and he was on site
That he
all
was
this
on
time.
site, that's correct.
I mean, so that would provide him some notice if it was true it wasn't poorly maintained.
Fair.
Right.
So,
Not missing anything on that.
okay.
All set.
Okay.
Pointed out that this is a situation where the defendant has raised 3 issues on appeal, all of which follow the abuse of discretion standard. And I would suggest that in each instance, Judge Wall exercised his discretion appropriately and that the verdict should be upheld. At the outset, prior to the commencement of the trial, defendant raised these issues in motion in limine. There was extensive discussion with respect to the anticipated testimony, both as it pertained to the prior instances of observations of the parking lot and on days prior to the date of this fall, as well as Dr. Wadd's anticipated testimony. And Judge Wall, in each instance, issued rulings as to why he found that the evidence was appropriate, which is referenced in our brief. But it's also referenced in defendant's brief as it pertains to the prior instances. On page 28 of the defendant's brief, they concede that the evidence of prior occasions of observations of the parking lot was appropriately admitted for purposes of notice. Judge Wall, in his...
Well, he concedes that the ones that were brought to the attention of his client were properly admitted. But you had quite a few. I mean, there was 5 or 6 witnesses talking about instances of bad maintenance, and many of them didn't say anything about reporting it any further.
Well, basically, the testimony comes in 3 categories, Your Honor. 2 of the witnesses who did identify prior instances of icy conditions and dangerous conditions in the parking lot were employees of Leomar Industries, one of the defendants in the case. You had the office manager, Susan Alden, and she testified that she observed ice in the parking lots on occasion. She also was the person who received complaints from the tenant, 1-800 East West, and there is testimony from the office manager for 1-800 East West that he communicated no less than 12 times in the prior winters to Leomar Industries that the parking lot was in a treacherous condition. She also acknowledged, Susan Alden also acknowledged that she received such complaints.
So as to notice, was there any limiting instruction by the court to the jury that the purpose of that testimony was for limited to notice?
Yes, Your Honor, there was. There was. The principal of the 2 defendants, Mr. Milagney, also testified that notwithstanding, as Judge Ditkoff pointed out, that he testified that he was out there on a constant basis, starting at 4 or 5 o'clock in the morning, taking care of any conditions in the parking lot that arose. He also observed icing conditions in the parking lot over the time that he was there. And then the 3rd witness from the defendant corporation, Mr. Rowe, testified that although he was retained to plow the parking lot when there was snow, he had no subsequent responsibilities with respect to maintaining, salting, or sanding the conditions in the parking lot. On top of that, then you have the witnesses from 1-800 East West. In some instances, there's no direct communication testified to between their observations and Leomar Industries or Ms. Alden on behalf. I agree with that. But that would go towards notice as well, and would also go towards the foreseeability of the harm, because some of these witnesses testified that they actually had occasions where they slipped in the parking lot. So as it pertains to the prior testimony, in each instance, there was a valid explanation as to why it was relevant. On top of that, it went to rebut Mr. Milagney's testimony. Mr. Milagney was the first witness at trial, and he testified, as you pointed out, Your Honor, that he was out there meticulously taking care of the parking lot. So the evidence would be admissible, if for no other reason, to rebut that the parking lot was in a pristine condition. These witnesses testified that wasn't the case, so it would be admitted for that purpose. As it pertains to Dr. Ward, the testimony of Dr. Ward, as it pertains to the flow of the water, is essentially lay testimony. The focus of his testimony was where'd the water come from, where'd the ice come from. And he testified basically about weather temperatures, that there was a snowfall on January 27th, and if the defendants, as they testified, would push it up into banks, then gravity would serve the purpose that water does flow downhill. And that was essentially how he said that.
The judge didn't seem to think much of Dr. Ward's testimony. I couldn't really get it from a cold transcript. I don't know if you could enlighten me as to what Judge Wall was talking about.
Well, I know Judge Wall felt that I would ask Dr. Ward a simple question. Dr. Ward would answer something else. He commented to that extent. But as far as the essence of the testimony, he also said that I got what I needed from him, that he came in and testified where the ice came from, how it got there, and when it would have gotten there in relation to the plaintiff's accident. So he established the foundation that the ice would have been there for a period of days prior to my client's fall. So when we argued that the defendant didn't exercise reasonable care, they had a basis to establish the length of period of time that the hazard existed. Any further questions, Your Honor? Thank you.
Thank you, counsel.
We're all set. Thank you, everyone. Thank you to all the litigants. Thank you to our court staff, the clerk's office, to our court officers. Thank you to the litigants, and thank you to all of you who came today and for those who made it possible.
I want to doing the Q&A here.
Well, now, if you'd like, now that the formal proceedings are over and the session is concluded and the cases are submitted, we're happy to stay here for a few questions and answers if you'd like.
I think additionally, we'll be going downstairs to have further Q&A, but for who's ever here, if you have any questions, feel free.
And why don't we take off the robes and...
Judge Sullivan won't let us leave unless there's 3 questions asked, so I'd encourage you to think of something.
Come on, you got a question, I can see.
Go ahead, sir.
Just stand up. I'm Neil Delco. I'd like to know if these seem kind of like trivial cases, a slip and fall on ice. Is this, do you hear these cases just because they request it, or do you select cases?
We are an intermediate court of appeals. We hear all cases filed by any litigant of any sort except for 2 categories: first-degree murder cases, which go to the Supreme Judicial Court, and any other cases which the Supreme Judicial Court takes. But all criminal defendants have a right of appeal, and all civil litigants have a right to appeal, although they typically must do so either pro se or with a lawyer whom they retain, unless in certain limited circumstances counsel is provided in a civil case. That said, I don't think there's ever a small case for the people who are involved.
The result of that slip and fall was a jury verdict of in excess of $500,000. And the issues that are raised were substantial evidentiary issues regarding admissibility of similar acts or similar events, which is a very substantial issue, quite frankly, and the admissibility of testimony by an expert that went beyond theoretically his expertise. So they're not as simple as they might appear that it was a slip and fall. You know, why are we wasting court resources on it? It had a lot of significance, to be honest with you.
In the criminal cases, there's a free lawyer if you're indigent, and so almost all of those get appealed. But a civil case, you know, someone thought it was worth paying a lawyer to argue it, so there's some limitation on that, at least if they're tort.
A lot of the cases, there's maybe a couple thousand cases filed every year in the appeals court, and they're screened by the clerk's office. Ms. Thomas is one of the members of the clerk staff, and they screen the cases to determine which cases have an argument. They're called A cases. We call them A cases. And then there's B cases, which are non-argued cases. So we as a panel hear a certain number of argued cases, and we also hear a certain number of non-argued cases where they're just submitted on the papers, on the briefs and the record.
But nothing gets through our court without 3 judges reading the whole transcript and the record and deciding it, which is not the case for every appellate court, but is definitely our practice.
In the back.
I heard you mention the word record a lot. Could you just explain what that means?
Sure. Because cases come to us either because there's been a motion which ended the case or a trial, we don't hear the evidence, as you can tell. We don't see the witnesses, but the parties, as part of the process of appeal, put that all together. So here on my iPad now, used to be, we would have had paper going from one end of the table to the other, are all the exhibits, all the testimony in transcript form, all of that comes with the case. And we, because we're only reviewing to see if an error was committed in the trial court, we are limited to what we are given as a record and what they gave the judge in the trial court as a record. So that's what that's about. Because otherwise, you can't start bringing stuff in after the fact, or it wouldn't be fair, right? You had your trial or you had your motion. It wouldn't be fair to say, oh, slipsies, I want to give you something new now.
So the trial court hears all the evidence, We don't rehear any evidence. No evidence is submitted to us. We just review what was done by the trial court, whether or not the judge made proper rulings and the like. That skydive case, it was the next to last case we heard today, that had an appendix of over 3,500 pages. There were over 3,500 pages in their appendix that we, I mean, you might have seen a lot of, well, I know I was, I don't watch my other colleagues, but I was going through pages as they were talking. I was listening, but going through trying to find references and maybe question them on certain things. But with the 3,500s, it's, I mean, I was trying to find, there was a certain affidavit we were talking about, and I was trying to locate that in the record as they were talking about it. So the record is what we live by and what makes the case for us. The argument is supplemental to, they've have a written argument in the form of their briefs as well before us. So it's a lot of paper that we've reviewed before we came in here. I know Judge Sullivan said at one point, perhaps you could explain, I think it was the last case on the slip and fall, what the case is about. That was for the benefit of the people that were here observing. We knew very much what the case was about because we had all spent multiple hours reviewing all the documents that had presented to us. Thank you, Mr. Hillman.
Right
Yes, sir.
Here.
I want to say thank you for coming to Fitchburg State University today. This was a great first experience, first time we got to see an actual appellate argument. We have an amazing moot court program here with an excellent professor and coach. One thing that I loved about moot court was the rebuttals. And I was wondering if, like today, I didn't see any rebuttals for the 6 rounds. And I don't know if it's more common during the actual arguments to have rebuttal arguments.
No, we never allow it
No.
because it just goes back and forth and it's because it's there's already been an opportunity for all of that in the trial court, and the parties are thought to have distilled what they have to say at this point. So each side gets 15 minutes. The same is true in the Supreme Judicial Court. But how many students are here? Right. Well, for those of you who are here, I just wanted to point out and give people an opportunity to speak. You know, the judges, we get all the airtime, but our court is a huge place with a lot of different people who do very important things. And we have today Ann Thomas from the clerk's office, and we have John Harrison and Ron Speight from the from our court officers. And if they're willing, they could take a couple of minutes to say how they got involved in the court, or you may want to ask questions of them later as well as us later.
Yeah.
So I'll just take a moment. So I'm an assistant clerk. There's 4 assistants, a first assistant and a clerk. And you have to be an attorney for a certain number of years before you can apply for that position. And in my experience, I had both criminal and civil experience as an attorney, and also mostly did appellate work. And the clerk's office is the liaison between all the litigants and the public and the court. You know, you can never speak to a judge, you know, ex parte, so everything goes through the clerk's office, all the briefs from the start of the case through, and we move the case through, and we eventually either schedule argument or submit the case just on briefs, and then, you know, when it's time for argument, get everything that the judges need in order to review the case prior to argument. And then we'll also carry through, and when they make their decision, get that on the record. We're also try to be very helpful. If anyone has any questions, we deal with the general public. And then we also, of course, there's many people who represent themselves, so they do not have an attorney. And they're held to the same standard, but we, of course, procedurally, how to move your case through, what you need to do to file your brief, and those type of questions we can answer. So we have a wonderful website that the clerk's office put together that has a great help site, a self-help site, which I have to say, because when I refer a pro se person to it, I always like to say that the attorneys love it too. It has quite a lot of detail. And the whole reason is that there's these rules of appellate procedure, which are quite detailed. And for the whole process to work, we have to follow those. So we try to help you to understand those.
And we also have people in the clerk's office who do not have law degrees, who do other things within the clerk's office. In the same way that in a trial court, there would also be people involved in probation and the like, but
We have a large staff.
would you like to comment?
Good. Is it afternoon yet?
Yep,
Not
just
yet,
turned
we have
afternoon.
2 minutes.
Good afternoon. My name is John Harrison. I've been a court officer in the appeals court for 15 years. I started in 1997 as an associate court officer in the trial court in Suffolk Superior Court. I did that for 4 years, and after 4 years I was promoted as a court officer to Suffolk Superior Court. And I did that for 2.5 years. And in 2003, the appeals court hit the lottery by hiring me as a court officer. I hit the lottery. And I've been here ever since, 15 years. Happy.
They ensure our safety. Quite frankly, when things happen, and not so much in the appeals court, but because there's not as much public that comes in, but in the trial courts, court officers are the eyes and ears of the safety in the building, as are our court officers in the appeals court. It's just, it's interesting to watch when things start happening and there's a disruption of any kind, because I've sat there and kind of just watched it unfold, but the court officers are immediately in action once something happens, and it's very impressive that they respond so quickly to any kind of disruption in a courthouse.
Oh, and just one point on that too. Unfortunately, we
Started a number of years ago to need to have a court officer in the clerk's office. And, it just really helps. Unfortunately, some people, these experiences can be emotional, it can be difficult, and sometimes to just help us to, help them through the process. But we very much appreciate that, and they stay with us through the day.
Like John, to the appeals court, and then in 2001 I got the call from Lowell saying, "Hey, we're ready for you. You want to go?" And I said, "No, I'm here now." It's been a great experience. We've done a lot, and the appeals court is, a family type. It's different than a trial court. I started out, Lawrence was my first court, Lawrence District Court, which is a lot of chaos. From Lawrence, I went to Lynn. From Lynn, I went to Suffolk Superior, like John. And that's no certain pattern that you follow. You just, get sent where you're told to go, for the most part. And I've been here ever since 99, and I plan on retiring from here at some point in time.
So, and then if any of you go to law school, maybe you'll apply to be law clerks, as our 3 wonderful law clerks sitting over here who helped us so much to get prepared for today. I hope that any of you who are students here or who listen to this later will consider some kind of a career in public service and will consider our court system, because it's important work.
Pitchburg Access Television. I just want to thank the court. It was a very easy process to go through to have our television cameras here today. But I also want to thank the guys working the cameras. They started yesterday getting this whole setup ready in conjunction with Fitchburg State University, and I think they did a great job. So, but it was a great process going through the court. It was very easy. We thank you very much.
Thank you. All right, I bet people might be ready for lunch. Oh, the website, I'm sorry.
it's under mass.gov, and they also recently redid that whole website.
It is very easy to find.
And just appeals.
But don't hesitate to call the clerk's office if you can't find it.
Thank you.
You're welcome.